We will be covering the legal aspects of an insurance contract. Under legal aspect, we will be covering the following topics. Insurance contract is a contractual agreement in which the insurer agrees to provide financial protection to the proposer against certain specified risks for a price or consideration known as the premium. The contractual agreement takes the form of an insurance policy. Elements of a valid contract are offer and acceptance, consideration, agreement between parties, free consent, capacity of the parties, and legality. Offer and acceptance. There must be an agreement based on a lawful offer made by person to another and lawful acceptance of that offer made by the latter. Usually, the offer is made by the proposer and acceptance is made by the insurer. Consideration means that the contract must contain some mutual benefit for both the parties. In case of insurance, the premium is the consideration from the insured, and the promise to indemnify is the consideration from the insurers. Agreement between the parties. Both the parties should agree to the same thing in the same sense. In other words, there should be consensus ad idem between both parties. Capacities of the parties. Both the parties to the contract must be legally competent to enter the contract. They should have attained the age of majority at the time of signing the proposal and should be of sound mind and not disqualified under law. Legality. The object of the contract must be legal. For example, no insurance can be had for illegal acts. Free consent. There should be free consent while entering into a contract. Otherwise, it is a void contract. Consent is said to be free when it is not caused by coercion, which is pressure applied through criminal means. Undue influence, which is when a person is able to dominate the will of another, uses her position to obtain an undue advantage over the other. Fraud, which is the deliberate concealment of facts or misrepresenting the facts. And mistake error, which is one's knowledge or belief or interpretation of a thing or event. Thank you. In this video of the lesson, Legal Principles of an Insurance Contract, we will be discussing the special features of an insurance contract. Apart from the essential elements of a contract, insurance contracts also abide by special principles mentioned herein. The concept of humorima fides is defined as involving a positive duty to voluntarily disclose, accurately and fully, all facts material to the risk being proposed, whether requested or not. Proposer has a legal duty to disclose all material information about the subject matter of insurance to the insurers who do not have this information. If utmost good faith is not observed by either party, the contract may be avoided by the other. Material information includes one's own medical history, family history of hereditary illnesses, habits like smoking and drinking, absence from work, age, hobbies, financial information like income details of proposer, pre-existing life insurance policies, occupation, etc. Material fact has been defined as a fact that would affect the judgment of an insurance underwriter in deciding whether to accept the risk, and if so, the rate of premium and the terms and conditions. We have already discussed in the earlier slide about the material information that one should disclose. There are certain material facts which the proposer is not obligated to disclose, unless there is a specific inquiry by underwriters. These are measures implemented to reduce the risk. For example, the presence of a fire extinguisher. Facts which the insured does not know or is unaware of. For example, an individual who suffers from high blood pressure but was unaware about the same at the time of taking the policy. Facts which could be discovered by reasonable diligence. Matters of law. Everybody is supposed to know the law of the land. and facts about which the insurer appears to be indifferent or has waived the need for further information, the insurer cannot later disclaim responsibility on grounds that the answers were incomplete. Breach of good faith can arise either through non-disclosure or misinterpretation. In case of life insurance contracts, the duty to disclose is present throughout the entire period of negotiation until the proposal is accepted and a policy is issued. Non-disclosure may arise when the insured is silent in general about the material facts because the insurer has not raised any specific inquiry or gives evasive, inadvertent answers to queries raised by the insurer. Misrepresentation can be of two types. Innocent misrepresentation, which relates to inaccurate statements made without any fraudulent intention, and fraudulent misrepresentation, which refers to false statements that are made with deliberate intent to deceive the insurer. An insurance contract generally becomes void when there is a clear case of concealment with intent to deceive or when there is fraudulent misrepresentation. The expression fraud means any of the following acts committed by the insured or by his agent with the intent to deceive the insurer or to induce the insurer to issue an insurance policy. A. The suggestion as a fact of that which is not true and which the insured does not believe to be true. B. The active concealment of a fact by the insured having knowledge or belief of the fact. C. Any other act fitted to deceive. And D. Any such act or omission as the law specially declares to be fraudulent. Note that in the case of fraud, the onus of disproving lies upon the beneficiaries in case the policyholder is not alive. Insurable interests is the basis of contract. The existence of insurable interest is an essential ingredient of every insurance contract and is considered as the legal prerequisite for insurance. Subject matter of an insurance contract is the insured's financial interest in that property. It is only when the insured has such an interest in the property that he has a legal right to insure. For example, in gambling, one could win or lose, but in a fire, one can have only one consequence: loss to the owner of the house. The owner takes insurance to ensure that the loss suffered is compensated for in some way. The interest that the insured has in his house is termed as an insurable interest. The presence of insurable interest makes an insurance contract valid and enforceable under the law. In life insurance, insurable interest should be present at the time of taking the policy. Thank you. In this video of the lesson, Legal Principles of an Insurance Contract, we will be discussing the special features of an insurance contract. Proximate cause is a key principle of insurance and is concerned with how the loss or damage actually occurred and whether it is indeed a result of an insured peril. Under this rule, the insurer looks for the predominant cause which sets into motion the chain of events producing the loss. Now let us see how the principle of proximate cause apply to insurance contracts. In general, since insurance provides for payment of death benefit, regardless of the cause of death, the principle of proximate cause does not apply. However, many insurance contracts also have an accident benefit rider, wherein an additional sum insured is payable in the event of accidental death. The principle of proximate cause would become applicable in such instances. Adhesion contracts are those that are drafted by the party having greater bargaining advantage. Generally, the insurance company has all the bargaining power regarding the terms and conditions of the contract. They provide the other party with only the opportunity to adhere to, that is, to accept the contract or reject it. To neutralize this, a free look period, which is within 15 days of receiving the policy document, has been introduced, whereby a policyholder, after taking a policy, has the option of cancelling it. The company has to be intimated in writing, and premium is refunded, less expenses and charges. The principle of indemnity is applicable to non-life insurance policies. It means that the policyholder who suffers a loss is compensated so as to put him or her in the same financial position as he or she was before the occurrence of the loss event. The insurance contract guarantees that the insured would be indemnified or compensated for the amount of loss and no more. Indemnity might take one or more of the following modes of settlement: cash payment, repair of a damaged item, replacement of the lost or damaged item, and restoration, reinstatement. For example, rebuilding a house destroyed by fire. Subrogation means the transfer of all rights and remedies with respect to the subject matter of insurance from the insured to the insurer. Subrogation follows the principle of indemnity. It is the process that an insurance company uses to recover claim amounts paid to a policyholder from a negligent third party. Here is a quick look at the topics covered in this lesson. Thank you.